Welcome to GameChanger Law Advisors, Simplifying the Law series. Let's learn more on related party transactions. In part 1, we learnt about who is a related party under the Companies Act. In part 2, we will dive a little deeper and learn about transactions regarded as related party transactions. Section 188 provides a list of 7 types of transactions regarded as related party transactions when conducted between related parties. These are 1. The sale, purchase or supply of any goods or materials between related parties. For example, let's take Company X. Company Y is another private limited company where director of Company X is also a director. So like we saw in part 1, Company Y is a related party of Company X. If Company X is manufacturing a product for which it requires raw materials and decides to purchase these raw materials from Company Y, this would be a related party transaction. Now keep in mind that whenever we refer to Company Y in this video, we mean Company Y that is a related party of Company X. 2. The selling or otherwise disposing of or buying property of any kind. For example, we again take Company X and Company Y that are related parties. Company X wishes to buy Company Y's computer systems. Now this would be a related party transaction. Property could also mean shares of Company Y or a warehouse belonging to Company Y, that is property of any kind. 3. Leasing of property of any kind. For example, we again take Company X and Company Y that are related parties. Now, if Company X wishes to lease an office building belonging to Company Y, this would be a related party transaction. 4. The availing or rendering of any services between related parties. For this example, we will take Company X and a consultancy firm in which key managerial person of Company X is a partner. So the consultancy firm is a related party of Company X. If Company X wishes to utilize the consultancy services of this firm, it would be a related party transaction. 5. The appointment of any agent for purchase or sale of goods, materials, services or property. Let's say that Company X appoints Company Y to act as its agent to help Company X lease its property to a third party. This transaction, that is the appointment of Company Y as an agent, would be considered as a related party transaction. 6. A related party's appointment to any office or place of profit in the company, its subsidiary company or associate company. Now, what is meant by an office or place of profit in the company? If a related party receives any payment or remuneration other than the regular salary or perquisites due to him or her for rendering any technical services, professional services, etc., then such position held by him or her is an office or place of profit in the company. For example, let's take a web design firm which is a related party of Company X. And that firm is providing some website design services to Company X and is receiving a service fee. Then such firm's position as website designer for Company X will be an office or place of profit in Company X, and it will be a related party transaction. And last type of transaction is underwriting the subscription of any securities or derivatives thereof of the company. For example, if Company Y is subscribing to the securities of Company X and Company X underwrites, that is, hedges the risk of that subscription in return for some premium or remuneration to be received by it, it will be considered as a related party transaction. With that, we come to an end to part 2 of the related party transaction Simplifying the Law series. In part 3, we will learn more about the approvals and corporate compliances required when entering into related party transactions.